Chrissy, I wanted to take a moment out and ask you about powers of attorney, because I know you get a lot of calls about powers of attorney, and I know that there's one or two misconceptions out there that people really need to be clarified on. So tell us about them.
Thank you. Yes, the biggest misconception is that people think that at any financial institution, any financial account that they have, that the person or persons, including spouse, if they have named them as the beneficiary, the TOD, the POD on that bank account, that if the person that names them, if they are alive, but they are incapacitated in any way, even temporarily, that the person that they've named as beneficiary can talk to the bank on their behalf. That is not true.
So what we're saying is that sometimes clients come to us and say, Tom, hey, what I'm going to do is I'm going to add my child's name to all of my accounts. No. Don't do that. No, that's not wise. But we do want people to avoid probate on their bank accounts. How do they do that? They keep the accounts in their name only, but make them POD, payable on debt to their kids. A great tool to avoid probate. But what you're saying is that, yes, you make your bank accounts POD for the kids to avoid probate, but if you were in a car wreck or you got comatose, got Alzheimer's, just because their POD does not give them the ability to get into that money to pay your bills for you if under those certain circumstances.
Exactly. You must have a financial power of attorney. That financial power of attorney appoints, most of the time, it's going to be the same person that you have designated as the POD or TOD. That's perfect. But just realize the bank will not speak to your POD designation without the financial power of attorney, folks, if you are alive, because POD, TOD means you've passed away.
Okay, so folks, we want to make it clear too that there's a lot of people out there listening say, Tom, what are we worried about? We've got a power of attorney. Well, folks, what we want you to know is that it's not the law, but from a practical perspective, banks don't like powers of attorney, financial powers of attorney, that are more than 5 years old. So that in and of itself is a reason to get your financial power redone if it's more than 5 years old.
Correct. And Tom, I often tell people, you don't have to take our word for it. Go to your financial institution, take your existing financial power of attorney, and you ask them, because it's about what they say, not what we say. In that situation, exactly what you mentioned, if it is over 5 years old, those people call me back and say, Chris, yes, we need to update it because the financial institution will not accept this power of attorney.
Thank you, Chris. We appreciate it.